Thank you very much, Mr. Chair. So, again, I feel after that suspension it's important to recap to members what has happened so far, because the reason we are debating this motion is because the Liberal government, in their desire to ram through legislation that by their admission will censor what Canadians can say and post on the internet, they have decided to not hear from witnesses who desperately wanted to share their thoughts on this to ensure that we get this legislation right. And I'll just point out that, we put forward a number of suggestions for witnesses who, even within the 5 meeting constraints that we initially set out for our study of Bill C-9, never received invitations. And I do not impugn motive of this. I realize that you can only pack so many people into a meeting and so many people beyond that into 5 meetings. But there were representatives of civil society groups, of a range of political backgrounds, religious backgrounds, people who approached C9 from different perspectives, and some of them never received invitations. One of them was Lisa Bildy, who is a very accomplished lawyer, actually from London, Ontario, and she is the executive director of the Free Speech Union. And one of the reasons that the Free Speech Union decided to submit a brief and had wanted to appear as a witness on C9 was because of the significant implications that Bill C-9 has for freedom of expression. As the Free Speech Union said in its brief, C-9 will criminalize expression that should enjoy constitutional protection. They refer to a number of sections here, some of which revolve around the way that hate symbols are defined in the bill. Another is the way that the definition of hate is actually redefined with a lower threshold, a threshold that would exist if C-9 passes in the criminal code that is lower than what the Supreme Court has already determined should be the threshold for hate. And we have heard testimony on this before this committee in the few meetings we did have on the subject. Bill C-9 codifies the following definition of hate. Quote, the emotion that involves detestation or vilification, that word or is very important, and that is stronger than disdain or dislike. Now, when the Supreme Court has weighed in on this in the past over a couple of landmark cases that have enshrined freedom of expression in Canadian law, they talk about the extremeness of the emotion that activates hate. They have also talked about the need for detestation and vilification, again, showing that this is not just some menu that authoritarians can look at when they want to censor what Canadians say. And I say this as someone who is very supportive of the arguments that have been put forward by members of the Jewish community in Canada that there is a significant problem with hate, that Jews have been unfairly targeted by anti-Semitism, not just since October 7th, but for decades and decades and millennia. And we have seen hate become a lot more brazen in this country since October 7th. And a lot of the problems have been a failure by political leadership to deal with this. And when you speak to people who are in this space, when you speak to members of law enforcement, they will say that there is an enforcement problem. The issue is not the need for new judicial powers. It's not the need for a lower threshold for hate. It is the need for existing laws to be enforced. The Liberal government, for example, in Bill C-9 has proposed removing mischief as an offence when it pertains to religious property. Why would they do that? And where has the leadership been from the Liberal Party on the 100 and some odd churches that have been burned and vandalized in the last 5 years? I mean, we said that there should be, if we want to talk about hate against religious institutions, stronger penalties, mandatory minimum penalties, one might say, for vandalism and arson of religious property, whether it's churches, synagogues, or mosques. This is, again, what would have come had there been genuine consultation on C-9 with all groups affected by this. They wouldn't be removing a section of the law that has been regarded as a positive one. And we look at some of the other witnesses that were unable to testify. For example, we had put forward on our list the Right Honourable Beverly McLachlin, former Chief Justice of the Supreme Court of Canada, and someone who herself has actually been a tremendous defender in past Supreme Court rulings on freedom of expression. Now, I'm not sure whether Chief Justice McLachlin received her invitation, accepted or declined, but it's impossible to know when we lost 2 full meetings of witness testimony because of the Liberals' desire to condemn something as basic as a mandatory minimum sentence for those who view and traffic in just material they refer to in the decision as child pornography, but obscene and quite despicable child sexual abuse and exploitation material. Christine Van Gyn, we did have the opportunity to hear from Ms. Van Gyn of the Canadian Constitution Foundation in her opening statement, and I was very grateful we did, because the Canadian Constitution Foundation, and again, this is an organization that has done tremendous work in advocating for civil liberties for all Canadians. And she spoke about the chilling effect that this will have. Not only will more people be captured by Bill C-9 than are captured under current laws when it comes to governments charging people under Section 319 for hate speech, but more importantly, the government wading into this territory itself will actually send a chill that will make people more unable, that will make people less able to speak their mind. And this is such a critical discussion. Freedom of expression is a right that you could argue is the most important right. And the reason I say that is because if every other liberty and every other fundamental freedom were stripped away, except that one, you could use your freedom of expression to fight for all the others. You can use your freedom of expression to fight back for your property rights, for your democratic franchise. And any bill that engages this should be viewed with tremendous skepticism. And I do not take the Liberal government's position on here that this change in the definition of hate was benign, that this change in the definition of hate was really just a grammatical issue, not one that was genuinely going on with a different definition. That was what the Justice Minister said. And again, when the Justice Minister, the person who ostensibly is Canada's lawyer, doesn't understand the importance of words in legislation, it actually explains a lot about the housing and immigration systems, which this minister was previously responsible for. So I believe the Minister of Justice, Sean Fraser, has taken the same level of excellence that he brought to immigration and housing to justice, and C9 is a great reflection of this. This is a bill that has been condemned by, I believe all the Abrahamic faiths have come out with criticisms of this bill. I believe Jewish groups, Christian groups, and Muslim groups have all had a fair amount of criticism. And we have to look at this in the broader context of what the Liberal government has tried to do on speech. Remember, in the last 2 parliaments, in both parliaments, the Liberals tabled bills that they ostensibly said were about online harms. So specifically, harms on the internet. That was what the Liberals said they were targeting. And these bills actually re-engaged the Canadian Human Rights Act, Section 13, which was a bill, or a section of law, rather, that had tremendous concerns, was actually itself subject to a wide number of high-profile cases because human rights codes have a lower threshold than criminal code because they fall under civil law. And why that's important is because under Bill C-9, the new definition of hate doesn't just affect the criminal code. As my colleague Mr. Baber has pointed out quite eloquently, it affects all federal statutes, which includes the Canadian Human Rights Act. So C-9 is actually a backdoor way into engaging the very same provisions that were so vehemently opposed by so many people in this country in the previous 2 parliaments, with Bill C-60 or C-36, I believe, in the 43rd Parliament, and then C-63 in the 44th Parliament. And we still, by the way, do not know whether the Liberals intend to bring back another version of that. But I fear that what they are doing in C9, under the guise of taking hate seriously, hate that they have allowed to fester, they are telling the very people who have been failed by the government that they have their backs, and in doing so, setting the stage for something that I do not believe Canada can afford and I do not believe Canadians want. And then you have to address the question of timing, of why is this so needed at this particular meeting? Why were members given an abrupt deadline of not even 2 business days to submit amendments for a complex piece of legislation, amending the criminal law, the criminal code of this country, and told on Thursday at a meeting that was ended 2 hours early that you need to submit these amendments by Monday so that we can deal with them today. Now, we did that. We worked hard. If this bill is going to proceed, it needs to change. But in this form, it absolutely cannot proceed, which is why we have been raising so many concerns about this, as have witnesses. But at the very least, as members of Parliament, we have a right to hear from witnesses who want to speak out. A committee that was truly responsive to Canadians would actually be responding to all of the groups that have come forward that wanted to testify that have not yet testified. People like Lisa Bildy of the Free Speech Union, Mike Fagelman of Honest Reporting Canada, Arunesh Giri of the Hindu Canadian Foundation, David Gronofsky of B'nai B'rith Canada, Brian Doody of Duty Council Legal Services, Aislinn Jackson of the BC Civil Liberties Association, which, by the way, I would say has never once in its history been confused for a conservative organization, the BC Civil Liberties Association. Mark Joseph of the Democracy Fund traveled all the way here from Toronto and was not able to testify because the Liberals decided they didn't want to send a strong message that we will not stand for child pornographers in this committee. Dr. David Haskell, professor at Wilfrid Laurier University, where I actually had the privilege of teaching journalism very briefly. Talia Klein-Leighton, Canadian Women Against Anti-Semitism. Again, an outstanding witness that we did not get a chance to hear from. And there were witnesses proposed by other parties as well. This is not just asserting the Conservative offered witnesses' right to testify. It's Stephen Camp, formerly of the Edmonton Police Hate Crimes Unit, Michael Jacob, Office of the Special Envoy for Combating Anti-Semitism, the Alberta Association of Chiefs of Police, the Canadian Association of Chiefs of Police, representatives of the RCMP hate crime units. Again, you'd think that people who are going to be tasked with actually enforcing the provisions in C9 would be able to actually testify so that we understand what the implications are of the laws that we're proceeding with. Deborah Lyons, she is a representative of the Liberal government's efforts against anti-Semitism, and I don't believe any Jewish person in Canada would say that she has managed to rein in anti-Semitism or that the Liberal government has had a desire to do this. Mark Neufeld of the Calgary Police Service with the Hate Crimes Unit. Again, someone that you would think would be top of mind to get to hear from as members of the Justice Committee. Rabbi Daniel Michaelberg. He's the head clergy at Temple Israel of Ottawa. He's local. I believe he could have quite easily found time to come here if the committee allowed time to hear from witnesses on C9. Mohammed Hashim of the Canadian Race Relations Foundation. I know another witness that was proffered was former Justice on the Supreme Court of Canada, Rosalie Abella. I know her late husband was a tremendous scholar of anti-Semitism in Canada. Britton Hudson. I'm not familiar with Mr. or Ms. Hudson's work, but I believe that they were on the witness list for a reason. And Justice Committee members would have been able to learn something, perhaps. The 519. I mentioned Dr. Benjamin Roebuck. That was someone that I believed, and in our motion that we're debating right now, should be brought forward as the federal ombudsperson for victims of crime. I believe, given what Liberal bail laws have done over the last 10 years, the number of victims of crime has ballooned to a point where we probably need to get a few more helpers for Dr. Roebuck. Michael Levitt, Canadian Friends of Simon Wiesenthal Centre, another witness that would have had a great deal to offer us. Maureen Buchan, the BC Assembly of First Nations. In fact, we have not really heard Indigenous perspectives on this bill. Jackie Lombardi with Chiefs of Ontario. Again, another witness offered up that we did not, as committee members, get the chance to hear from. Jay Jayaraman of the Hindu Federation. Now, we have heard from some witnesses in the Indian community who have raised some pretty key concerns about the way that the bill describes hate symbols, specifically representatives of the Indian community, Hindu, Jains, Buddhists. They dislike the use of the word swastika. They also dislike the resemblance part of Bill C-9 because they're worried that this will be an assault on their religious freedom. And again, I don't think we can particularly trust this government to stand up for religious freedom. Others, Brian Sauvé, we had him on our bail study, but would have offered a lot on this as well with the National Police Federation. This is the union representing the brave men and women of the RCMP. We also have on the list Joseph Neuberger of the Canadian Jewish Law Association. There's an association of local Crown Council in Alberta. ALCA is the acronym. And Rochelle Dierenfeld was one of the witnesses that was put forward there, as was Michael Palawan, who is a municipal lawyer. I don't know what municipality. That might have been one of the things we would learn had Mr. Palawan been able to testify, as well as how he believes C-9 will affect civil liberties in Canada. Ted Cohen, who is the CEO of Hillel Lodge, again, very key witness that we have not had the opportunity to hear from. David Sachs, who is an anti-Semitism specialist with the Jewish Federation of Ottawa. Again, someone else local. In fact, if we wanted to hear from witnesses, I bet we could call up Mr. Sachs and have him come down right now and testify. But again, we cannot do that because we have been shortchanged our right as members of Parliament to truly study Bill C-9 because of this Liberal government's desire to ram something that attacks civil liberties through with as little scrutiny and accountability as possible. Terry Teegee, another witness, regional chief of the BC Assembly of First Nations, I bet was eager to travel across the country to testify because he thought members of Parliament and Canadians would have the ability to hear what he has to say. My colleague from the Bloc has suggested from the Barreau de Quebec, Marcel Olivier Nadeau. Again, I don't know what the Barreau de Quebec's view on Bill C-9 is, and I never will, unless this government agrees to give C-9 the proper study that it deserves and that we have a right to engage in as members of Parliament. There were other MPs who wished to appear. I have not read all of their briefs. I don't know if all of them have. Assembly of First Nations, Hussein Panju with the Canadian Muslim Lawyers Association, James Turk, who is the director of the Centre for Free Expression, Garrison Sethi, which is the Grand Chief of the Manitoba Kiwatanawi Okimakanak, and I apologize to the Grand Chief if I got that wrong, Anishinaabeg Nation and Union of Ontario Indians, Khaled Al-Kazaz of the Canadian Muslim Public Affairs Council, Louise Smith of Independent Jewish Voices. Now, I have a great many concerns with the rhetoric and tone of what Independent Jewish Voices says, but I also believe that we should be hearing from Canadians of all perspectives on this. Per Kroot of the Canadian Union of Jewish Students, Jeremy Johnson as an individual, Victoria Pruden, another potential witness who we were not able to hear from, the president of the Métis National Council. We have Nadia El Mabrouk, who's the president of the Rassemblement pour la Laïcité. Again, another witness we do not get to hear from, as well as Imam Mohammed Tahidi of the Global Imams Council, a man who's been an outstanding voice against radicalism, against religious extremism, not just in Canada, but around the world. I believe he's from Australia originally. And then Jennifer Boyce, who is the Director of Communications for EGAL Canada, another witness that we do not get to hear from. And again, we couldn't have heard from all of these witnesses in the 6 hours where Liberal obstruction denied us the right to engage in witness testimony, but we could have heard from some of them. And we could have, had we done a proper study on Bill C-9, one that is more concerned about getting it right rather than ramming it through quickly, we could have heard from a lot of these people. And in fact, some of the ones that I mentioned were not even invited to submit briefs. We had to proactively go to them and say that they should be submitting briefs if they want their perspectives to be heard. And I have some of those briefs available, and I don't know if they've been circulated to all members, so I will we'll cite a couple of them as it gets up here. But the point of this is that when we are talking about a bill that engages civil liberties, arbitrary deadlines for amendments that do not give anyone the opportunity to actually go through and thoughtfully go back and forth internally, debate these things, change wording. We had to submit ideas, and we were just given from the drafters, here are the amendments, no time to really make that many revisions. And I'm not saying there are issues with them. I'm just pointing out that when you have an arbitrarily imposed accelerated timeline like this, it makes it impossible to do anything with it if you wanted to actually go through the process of getting this right. I note that the Center for Israel and Jewish Affairs came out with a statement this week in which they expressed their desire not to see C9 pass carte blanche with a rubber stamp, but to actually be the product of cross-party consensus. And again, that is not...
I don't believe that is CEJA's position that they'd want us to not go to clause by clause. I think they do actually want us to go to clause by clause.
On that point of order, Chair, it's not a point of order.
Not a point of order.
I don't know. I think it might be.
I suspect you know it's not. Weren't you a chair once, Anthony?
It's not, Mr. Genius. You don't have the floor.
Neither does he.
No, it's Mr. G. You are allowed to speak here, but you do have to maintain the decorum of this committee. Mr. Lawton, try to stay accurate, please.
Thank you, Chair. I was incredibly accurate, and I can read directly from the statement here, and I appreciate
point of order, Chair.
my member opposite's opportunity to cite from this, because what CEJA had said, and again, all of us, I believe, should have been engaging with a number of stakeholders on this, but what CEJA said in its statement was that this needs to be the product of cross-party consensus. They want targeted amendments. It is difficult to offer targeted amendments and work across party lines when we are given a 2 business day window to do this. And again, is it more important to get it right, or is it more important just to get this through so the Liberal government can do what it loves to do, which is claim a win without actually doing the work, and in some cases going beyond to make problems worse? And I am aware that we are sitting on the House of Commons Standing Committee on Justice and Human Rights here, and I think that's tremendously relevant because it is this portfolio, the justice portfolio, that should have been engaged when the Liberal government previously invoked the Emergencies Act. And why that's relevant to the motion we are debating right now is because the Emergencies Act was government taking a statute that was designed for a very good reason, and some would argue a necessary reason, to deal with eventualities and emergencies that might require extraordinary action. And they used this to deal with a protest. The Trudeau government, the Liberal government, used the Emergencies Act to deal with a protest of people that were saying unkind things about the Liberal government. And in doing so, they violated the law. And I don't mean they violated some bylaw. I don't mean the government violated some minor statute. They actually violated the most supreme law in the country, which is the Constitution of Canada. And this is not my opinion. This is a decision by the federal court. The federal court, which said not only did the Liberal government break the law in invoking the Emergencies Act, but they broke the law in the measures that they chose to use the Emergencies Act for, namely restricting mobility and freezing the bank accounts of political dissidents. So how can we trust the government? And by the way, the Liberals are fighting that in court. They are appealing that decision in court. So how can we trust a government that so brazenly violates the charter rights of Canadians to redefine hate, and in doing so lower the threshold of what people can say on the internet, to lower the threshold of what people can say online? And after the Minister of Justice testified before our committee and admitted that Bill C-9 will, in fact, affect online speech, will affect social media posts, I saw on social media there are a lot of people looking at, from the United Kingdom, examples of police literally knocking on people's doors because of their tweets, because they posted something on social media. And these are not even people who were charged necessarily. Some were, which was quite shameful. But some of them were logged as, quote, non-crime hate incidents, a term that has emerged in the United Kingdom to deal with these cases where no one's even arguing there's a law broken, but they want to send a message. The state, the authorities want to send a message that you don't get to say things as a free citizen unless we tell you to. And it's interesting, and I mean, the Liberals want to claim to be a united front. I know that Stephen Guilbeault has quit the Liberal cabinet today. This is news that has just come out, which is quite interesting. And this is, again, another example where the Liberals have decided to ignore the Constitution of this country on energy policy. So if they're ignoring the Constitution on energy policy, in which the federal government has the latitude to approve pipelines, how on earth can we expect them to follow the Constitution when it comes to freedom of expression? Now, I suspect we might see Mr. Guilbeault in an orange jumpsuit scaling the Peace Tower any day now. So if members want to take a suspension to go and watch that, they may. But the reason that we are talking about the trustworthiness of the government here is because their desire to ram through Bill C-9 is itself a symptom of the issues that we've been raising and witnesses have been raising. You know, Bruce Pardy, a very accomplished lawyer and law professor from Queen's University, he testified before this committee, and he talked about how the way that the criminal code is written, misgendering could be a criminal act of hate under the right circumstances if the government decided to go down that way. And we should be able to, and by the way, this is not at all an endorsement of any particular expression. This is saying that as free people in a country that values freedom of expression, we should be able to engage in rigorous debate on issues that there is a range of opinion on. We should be able to have debates about gender and sexuality, about how we should be able to have debates about religion. We should be able to have debates and discussions about anything. And that doesn't mean we as a country are all in agreement. In fact, it means quite the opposite. And it certainly doesn't mean that the state has a right to decide what the correct positions are and what the incorrect positions are. And I say this, very aware of the fact that in where I'm standing on Bill C-9, there are going to be some forms of expression that make me very uncomfortable. You know, I'm defending the right of people to say things that I may find very hurtful, that may target beliefs that I hold dear.
You know, point of order, point of order. I'm having difficulty hearing Member Lawton because of all the noise on the other side of the room. Would Chair please ask for some decorum here?
Like as a head.
I mean, people can have discussions. Let's just keep it down so Mr. Lawton can continue.
Thank you.
Mr. Babber, you are sitting beside Mr. Lawton, so I assume you can hear correctly, but I get your point. Thank you, Mr. Lawton.
Thank you very much, Chair. And so as I said, I'm aware that in standing up for freedom of expression, I'm actually defending the right of people to say things that are very hateful about me, about things that I value. You know, for example, the right of someone to say that verses of Scripture are hateful. I would defend that right, Chair, and I would defend that right because I believe it's important. I believe that we should be able to defend our views and do so in an open forum. I believe wholeheartedly in the marketplace of ideas, and I do not believe that the government is capable nor legally entitled to make that determination. And on religion, I mean, I don't know what amendments to Bill C-9 are going to come forward in the course of our clause-by-clause consideration, but I do know that there is a private member's bill from the leader of the Bloc Québécois, Monsieur Yves-François Blanchet, that would remove the religious exemption, or the religious defense, rather, that exists in Section 319 of the Criminal Code. This is the defense that is crucially important for two reasons. Number one, it protects religious freedom. It talks about how you can use a defense if you are facing a charge under 319, that you were speaking in a manner that was under Section 319 3B, if in good faith the person expressed or attempted to establish by an argument an opinion on a religious subject or an opinion based on a belief in a religious text. And I believe the private member's bill also engages 3.1b, which is if in good faith they expressed or attempted to establish by an argument an opinion on a religious subject or an opinion based on a belief in the religious text. And I'm happy to read that section in French if members would desire. But the reason I bring that up is because this is not only an attack on religious freedom to remove that, as a private member's bill from the Bloc would do, and as has been suggested in testimony and discussion before this committee. But more importantly, that was a critical part of the Supreme Court's decision to uphold the existence of Section 319 in the first place. Because even when the Supreme Court decided that it was justifiable to have a section dealing with hate propaganda, even when they did that, they understood that it was necessary to have these limitations on that so that it would not be unconstitutional. And I think the dissent from former Chief Justice McLaughlin in the Keegstra decision is probably one of the greatest pieces, even though it was a dissent, one of the greatest pieces of legal writing in Canada, certainly when it comes to freedom of expression. But we saw that Section 319 itself was only saved because it had these carve-outs, because it had these protections. And again, I do not believe that you should have the right to say anything and everything simply because you hide behind religion. That is not what I'm saying. But more importantly, that is not what the law says. That is not what the criminal code says. A critical part of that section, 319(3)(b), is if in good faith. You cannot call for genocide in good faith. You cannot call for extermination of the Jewish people in good faith. You cannot call for mass disenfranchisement of people and violence in good faith. So this idea that we need to erode religious freedom and jeopardize the constitutionality of a section of criminal law that has been working in Canada because the threshold is so high. To say that we're doing that for an objective that isn't even connected to that removal is crucial. But it was proposed on this committee, and not as an amendment, I should say, but proposed as an idea. And of all of the times we did speak to witnesses, Mr. Chair, that was the only time you saw fit to intervene. And that is your prerogative. I'm not disputing that. But that was very concerning to Canadians who are of a variety of religious beliefs. And it engages why people are inherently distrustful of any desire by the government to reopen issues pertaining to hate, especially when there is a lower threshold, a lower definition. And my goodness, why have we forced something like this? What is the hurry when there are so many live concerns, so many very real concerns that we have not yet had the opportunity to really engage with as members of Parliament? And again, I do not accept the Justice Minister's view that there was no change to the definition, that omitting the word extreme, changing and to or, that was purely coincidental, that maybe auto-corrected it. Like, I don't buy that. And I don't think Canadians do either. Because that suggests one of two things has happened. Number one, the government is trying to sneak in a lower threshold for what constitutes hate speech, and by design, that it would literally lower the threshold by which you could be charged, which then it means it's expanding the scope of who can be charged for something. So that's a first point. And number two, that they're so sloppy they don't see that as being relevant. That the brightest legal minds in the country, who Canadians would hope are the ones drafting and introducing legislation, don't actually understand the differences between extreme manifestation and not, that don't understand the difference between and or. I mentioned earlier, I'm not a native French speaker, but even I, in French, a language I do not profess to be fluent in, could tell you the difference between a and ou, between and or. So there is a sneakiness to what C9 is doing, and I go back to the applicability of C9, not just to the criminal code, but to the Canadian Human Rights Act. The law that would have been changed by the Online Harms Act had Section 13 specifically, had that gone forward in the previous Parliament. I am glad with the news of Minister Guilbeault's resignation from Cabinet that he won't be around to table that. I know that was one he was very keen on, but I suspect that there are going to be others lining up behind him to do that, because we have seen a very transparent desire by this Liberal government to rein in civil liberties, to rein in the constitutional freedoms of Canadians, and specifically to rein in freedom of expression, which is sacrosanct, not just in Canada, but free societies. We just passed Remembrance Day, and I know many members of Parliament from all parties did videos for Remembrance Day that we could share with our constituents. And when I did my video, and when I spoke to members of my community, of veterans specifically, at a number of the cenotaphs I went to in St. Thomas, in Vienna, Ontario, and all of these places, Port Burwell, which was a very chilly day, but it was important to be there. There was a general sense that those who have fought and died in wars wearing a Canadian flag, or before that a British flag, did so because they wanted to stand up for the freedoms we hold dear in Canada. And that includes, maybe not chief among them, but certainly in the top, freedom of expression, freedom of speech. And you often hear, whenever we're talking about this, people say, especially when they want to defend liberal government incursions on speech, they'll say, well, freedom of speech is an American concept. We have freedom of expression here in Canada. And I would agree that freedom of expression is the term in Canada. But if you read jurisprudence on this, freedom of expression is actually broader than speech. Speech is what you say. Expression is what you say, it's what you do. Freedom of expression includes art. Freedom of expression includes speech. Freedom of expression includes song. I would not be so hurtful to the committee as to engage in song. I will not use my freedom of expression for that. But
It would be a legitimate point of order.
yeah, there we go. You would. It would be, Chair. I appreciate that. But
Decorum.
it's important to have that freedom. And it especially includes, and I go back to former Chief Justice McLaughlin's ruling on this, especially includes political speech. Because we realize that the right to disagree, especially to combat and challenge authority, is so critical. It is so critical. And one of the fascinating things when you see this discussion unfold is that the speech that is most necessary to protect is the speech that is most jeopardized and threatened by censorship. You know, I could say with my time here that I love puppies, and it's true, I do. My wife is a cat person, I'm a dog person, we compromise by having neither. But puppies are cute. Why do I need a constitutional right to free speech to say that? Because no one is going to try to censor me for it. But when we start talking about contentious political ideas, that is when censorship is engaged. When you start saying things that people don't want to hear, and people want to deny you the right to say. And I think this is an interesting point here, and the reason that we are trying to introduce this motion that we are is because we believe that if we are going to proceed with C9, it needs to be done properly. We cannot proceed with clause-by-clause analysis of C9. And by the way, it is not the most crucial justice issue facing Canadians. You know, the first clause of my motion is to prioritize the study of Bill C-14, the Bail and Sentencing Reform Act. Conservatives ran a campaign on stopping crime. And the Liberals were successful in the election. I congratulate them. They said they were going to take very serious measures to deal with bail and sentencing issues. I had expected when I was appointed to the Justice Committee that the very first thing we'd get to deal with would be a bail and sentencing bill. The only reason on this committee we got to engage in a study of bail is because Conservative members initiated it. We demanded a study of bail, and we have been doing this and are just about to finish it. We have our final meeting on this on Monday. And instead, the first justice legislation that the Liberals put forward was Bill C-9. The departmental officials could not say when they began working on C-9 relative to when they began working on bail and sentencing. And in fact, I'm not even sure at the time we had those officials that Bill C-14 had a number. We were just being told that it was coming, that something was coming. And then what we saw was a bill that addressed a lot of the concerns that Canadians have been talking about, certainly the Conservatives have been talking about, but did not go far enough, specifically in dealing with the principle of restraint. And we will hopefully have an opportunity to hear from witnesses about the shortcomings of Bill C-14. But again, we can't do that because the Liberals have decided to make censorship their first priority. They've decided to make C-9 their first priority. And again, they're going to say that Conservatives are the ones obstructing, when what we are saying is that we cannot pass through and wave through and greenlight bad law just because of arbitrary deadlines imposed by the Liberals. There is no way we would have gotten through clause-by-clause consideration of C9 today, which is why we've put forward this motion, resetting this committee's work, putting an end to Liberal obstruction of real justice issues that need to be addressed with, and where I think there's going to be more cross-party consensus than there is on C9, and that is the Bail and Sentencing Reform Act. I believe also the Bloc Québécois had put forward a very important study, which we were proud to support as Conservatives, on judicial appointments. Now, we have seen when judges are appointed, you can often look up their names in Elections Canada and find that coincidentally, many of them are past Liberal donors. So there is a little bit of a problem in the judicial appointment system. More importantly, in some of the heinous decisions we've seen from judges on bail and on sentencing, there are clearly competence issues emanating from the judiciary that need to be addressed, and I would hope would be in this study on judicial appointments. For example, I'd be keen to know why a judge in Quebec thought that someone who had hundreds of images of children as young as 3 being raped deserved a 90-day sentence. I would love to know why and how a judge who would make such a decision was appointed. But unless this motion goes forward, between C9 and C14 and other justice legislation coming before this committee eventually, whether it's private members' bills or something else, perhaps something dealing with child sexual exploitation and abuse material, as we have called on, this committee has called on the government to put forward before the end of the year, there's no way we'll be able to do this study. So again, it's almost as if we have given this authorization to proceed with a study that the committee, by which I mean the Liberal members of the committee, have no intention of actually proceeding with. And I remember also that we were expecting to engage in this committee's work on Tuesday and never received a notice of meeting. I don't know why. It doesn't matter for the purposes of what we're discussing here, but that would have been an opportunity. We would have been discussing bail, and it was yet another obstruction that prevented us from doing our work as members of Parliament on this committee. We have invited Minister Sean Fraser to appear before us to discuss his mandate and priorities. He did come forward on Bill C9 and was very eager to come forward on Bill C9. And I know when we were debating on this committee, it was interesting how that was a priority, to get him to only talk about C9. And we still have not had the opportunity to talk to him about his mandate and priorities. So Clause 5 of this motion, excuse me there, Chair, Clause 3 is that you be instructed to reiterate the invitation. I believe you passed it along. I believe the minister received it. I don't know if he put it in the filing bin that looks and sounds like a shredder, or if he was planning to make it to us at some point. But I think he should be reminded that he has an opportunity, not an obligation, I understand, but an opportunity to appear before us to discuss his mandate and priorities. And there are a number of priorities that I think are very interesting that I'd be keen to explore, such as why censoring what Canadians say online was more of a priority for him than dealing with bail and sentencing. I'd love to hear his response to some of the witnesses we've had from police associations and police services, including the OPP Commissioner, Thomas Carrique, who's also with the Canadian Association of Chiefs of Police, who came before us and said that the Liberal government's gun confiscation scheme was a waste of police resources when the actual problems police need to be dealing with are repeat violent offenders. So where the priorities from this government are is something that I'd be very keen to hear from the minister if he graces us with his presence on his mandate and priorities. So I just want to make sure he is aware that he has an outstanding invitation. You know, I'm a new member of Parliament. I realize sometimes an email can linger in your inbox for a while, which is why I think sometimes you need to bump it to the top there. And this motion, which I'm sure will have cross-partisan support, will reiterate that invitation. And I hope Minister Fraser joins us soon. And on C14, we will need to hear from the minister on that specifically. And I hope he will, when he testifies to that, address why he is trying to tweak the principle of restraint instead of getting rid of it. Why he is trying to really skirt around the edges of the core problem that has been identified by so many people in this country that have come before this committee and other stakeholders and communities all over, that the principle of restraint, that you can draw a direct line between that principle and the revolving door bail system that has resulted in criminals getting released on the streets over and over and over again, sometimes hours after they've been arrested. And it is interesting that in the last week, the Ontario government came out with an approach that I think is important, and I actually would love to hear testimony from the Ontario Solicitor General on this, that would reimpose cash bail. This was something that was identified by a couple of our witnesses on the bail study, and I suspect would come up during C-14, because C-14, one of its major shortcomings, is not dealing with the surety system. It actually makes no changes to the surety system, in which you have criminals vouching for criminals, you have unenforceable bail conditions, does not change that at all. And why that would be important to hear is because bail conditions, sureties, are a crucial part of the bail system. So I would actually say that we could learn a little bit from what various provinces are doing. And again, it's a cross-partisan consensus. Wab Kinew, who's the Premier of Manitoba, and he is a New Democrat, so I suspect he and I disagree with each other on a lot of things. But he had a harder line on what we should do with people who peddle in child sexual abuse and exploitation material. I believe his exact line were they should be buried under the jails. And from the Liberals, we got 6 hours of obstruction and hand-wringing instead of passing a very simple motion. A very simple motion. Now, I said, Chair, that we should actually invite or reiterate our invitation to the Justice Minister. He's apparently watching because he's tweeting about this committee meeting right now. Minister Fraser says the Conservatives are obstructing the Justice Committee to prevent it from advancing laws to address hate crime. It's interesting. The minister has time to watch this committee, but he doesn't have time to visit the committee and testify on his mandate and priorities. And we are not obstructing. We are making an important point here, which is that we cannot stand for censorship shoehorned in under the name of expediency, under the guise of combating hate, when this is a Liberal government that has no moral authority to do anything connected to freedom of expression, and certainly has no moral authority to take a stand against anti-Semitism when there has been anti-Semitism that the Liberals have been criticized by members of the Jewish community for allowing from within the party. I remember when Irwin Cotler, a lion of Canadian politics, one of the most vocal advocates for Jewish rights and human rights in the world, argued that Mr. Anthony Housefather, who's been very engaged in the C9 study, should leave the Liberal caucus over their position on these critical issues. So I think there are a number of things that show that we should not, to quote the finance minister, take any lessons from the Liberals on these issues. If we are to engage in a genuine discussion of what Bill C9 seeks to do, it must be responsive to the witnesses we've already heard from, who have been talking about the assault on civil liberties embedded in Bill C9. That's a very important part of this. And more importantly, we need to have the ability to hear from other witnesses that have wanted to come forward and share so many crucial things. And again, the calls have been coming from Indigenous groups, from Muslim groups, from LGBT groups, from Jewish groups, from individuals, from legal scholars, from civil liberties activists. Mark Joseph from the Democracy Fund, who came here, submitted a brief on C9, which was authored alongside Adam Blake Galipo, who is a senior litigation counsel for the Democracy Fund. Mark Joseph is the litigation director there. And they offered some positions that I think were very important to have heard from them on regarding the section of C9 dealing with willful promotion of hatred, terrorism, and hate symbols. And what's interesting here, and we also heard similar testimony from the lawyer who joined us from the Canadian Civil Liberties Association about this, that there is already a provision of the criminal code that can prosecute someone for displaying a hate symbol. And I mentioned, I believe it was when I was questioning Minister Fraser, I can't recall precisely, but there was a case in my own riding just outside of St. Thomas, Ontario, in which a man was charged with hate propaganda. He was charged with incitement, rather, under Section 319 of the Criminal Code. And one of the reasons he was charged was because he had a swastika mowed into his lawn, which was very distressing to the community, and police laid a charge. Now, not only did they lay a charge, they would have done so with the Crown's consent. And because it was a Section 319 charge, they had to lay that with the consent of the Attorney General. So this tells us two things that are very important about Bill C-9. Number one, that hate symbols can already form the context that is used to lay a charge against someone for hate. And number two, that the Attorney General consent requirement is not a veto on these charges. The Attorney General consent requirement actually is part of a necessary stopgap that prevents abuse and actually gives law enforcement an opportunity to get some counsel on this that they may need before they lay a charge. Again, knowing how high the stakes are when you're charging someone for what may be political expression, when you're charging someone for what they say or what they do, or in this case, what they mow into their lawn. So we already have authorities under criminal law in Canada that have been under-enforced. We have authorities that prevent people from being able to block access to a synagogue or a school. We have mischief against religious property. We have charges that deal with incitements to genocide. And I know we've heard from witnesses about some of these incitements to genocide, when people have gotten up and called for intifada, very violent rhetoric against Jewish people, when people have chanted from the river to the sea, which is literally calling for the eradication of Israel, the only Jewish state in the world. And the questions we should be asking are why law enforcement have not been laying charges that they are legally authorized to, and a lot of that comes back to political leadership. So to return to the brief that we received from the Democracy Fund on hate symbols, I shared that bit of context just to establish that hate symbols are already things that can attract charges under 319. What they say in this brief, individuals have been charged under Section 319 for the display of the hate symbol. And they weren't referring to the case that I was in St. Thomas. They were referring to another case in January of last year where a man who held what police called a, quote, terrorist flag at a protest was charged with hate crimes under existing laws, before C9 was even a twinkle in this government's eye, before this government even existed, a government that so often tells us it is a new government. And display of the Nazi Hakenkreuz, which I realize there is some contention around whether one can or should call it a swastika, but that is, again, something that can be and is often informative to the decision by police, with the Attorney General's consent, to laying a hate charge. And the Democracy Fund raised what I believe is one of the most crucial objections to Bill C9, which is the way it redefines what hatred is. Because this is when we can go far beyond, and we must go far beyond, the Liberals simply saying that they are trying to just clean up some laws and trying to add some more clarity. There is no clarity given. This is a new definition. It departs significantly, the Democracy Fund writes, departs significantly to the definition used by courts since Keekstra, and I would note that the Keekstra definition has been reaffirmed in subsequent cases. In the bill, hatred means the emotion that involves detestation or vilification that is stronger than disdain or dislike. In Keekstra, it is an emotion of an intense and extreme nature, not just extreme, as I mentioned earlier, an intense and extreme nature that is clearly associated with vilification and detestation. So we have the and or distinction, we have the intense and extreme versus simply the emotion. And I realize these are emotional subjects. I realize it's emotional when we're talking about people that are saying things that are incredibly hurtful. And I do not take the position I do on this because I'm defending calls to genocide. Quite the contrary. I want people who break the existing laws to be enforced to the fullest extent of those laws. But what I do not support, and no Canadian who values freedom of expression could ever say they support this, is trying to cast a wider net on political expression that may be offensive, but is also what freedom of expression means. Again, freedom of expression does not exist for the benign. It does not exist for things that are not controversial. Freedom of expression protections exist precisely for things that are. And I look at how we have changed, how society has changed on so many social norms. There was a time when Tommy Douglas, who was a lion of socialism in Canada, a lion of the New Democrats, said in a prime ministerial debate that homosexuality was a mental illness. And that was a progressive view at the time. And now we have a situation in which we all realize the importance of equal rights for people of all sexual orientations. And this is something that shows how what is controversial in one era is a norm in another. And we only get there when we have the ability to engage in debate and discussion. And again, courts have reversed themselves as well. I mentioned Beverly McLaughlin. It was, about 30 years ago or so that the Supreme Court ruled there was no right to die by maid. And then you fast forward from the Rodriguez decision to the Carter decision, and the court has a different view because norms change over time. So we should not be stymieing debate and discussion when that is arguably the most important freedom and liberty that we have in this country. And where we go from there, and I'll move to my second point now, where we go from there is that if we do not take a stand now, an unequivocal stand, and draw our line in the sand and defend freedom of expression, we are going to allow a government that has shown a reckless disregard for civil liberties to offer more unchecked power. These erosions happen gradually, but they are very difficult to reclaim. And I note what was argued by Christine Van Geyn of the Canadian Constitution Foundation, which I mentioned her testimony earlier, but it isn't just that more people will be charged under Section 319 or potentially under the Canadian Human Rights Act or potentially under the Canadian Labour Code. My colleague Mr. Baber has pointed this out, the incredible risk of applying this definition to all federal statutes. So that is in and of itself quite interesting. But again, this is not a case where we should ever put the power to government and just hope that they won't abuse it. I believe it was Maya Angelou who said, when people show you who they are, believe them. The Liberal government has showed us who they are time and time again, including with the Emergencies Act. And I had the great privilege of interviewing Dr. Maya Angelou back when I was in radio. And I will say that I'm having some deja vu to that today. But the late poet Maya Angelou had an incredible view about the human spirit and artistic freedom. And it's interesting when you look at artistic freedom, some of the most vocal critics of the Online Harms Act when it came up were people on the left. Margaret Atwood, who I put up there right with the BC Civil Liberties Association. I don't think anyone has ever confused Margaret Atwood with being a conservative. If she were ever to run for office, I do not believe I would be sitting anywhere near her on our side of the aisle. But Margaret Atwood, she understands a thing or two about authoritarianism. She wrote The Handmaid's Tale, a book which was adopted into a TV series, which I believe they filmed in Cambridge, which is the riding held by my colleague Connie Cody. And The Handmaid's Tale shows an extreme example of what happens when an authoritarian state expands its power. And as we saw in that, it did not happen immediately. It happened gradually. So we have to be very careful about things that look like they are inconsequential, things that look like they are benign, but actually are not. And I go to our point on
of order?
6.
Yes. I'd just like to point out that we have, and Mr. Lawton, what he's been going on about, and the conservative filibuster continuing. I'd like to point out we have members of the very communities he is talking about who are sitting in the audience wanting this bill to go
Chair,
forward.
I have a point of order.
There are
This is not a
officials
point of
here
order.
who are
it's not
ready
a point
to
of
help
order.
us proceed with clause by clause.
It's not a
and
point of order.
everything
I
he's
can't
saying.
determine whether it's a point of order if I can't hear it, can I, Garnet? So just park it for a second, and I'll get to you. Ms. Dillon.
So out of respect for our audience members who are here wanting this bill to go forward, and they don't comprehend what is going on right now, it's a conservative filibuster to block the clause by clause so this bill can go forward. The very organizations and communities you mentioned, they're all in the audience. Look at you. They're all here, left their work, left whatever, to come and assist this committee to see this bill move forward. We have officials here who would like to see the clause by clause go forward. Please, if we can do that, I think this is going nowhere, what you're saying. You're just having circular reasoning. So can we move forward, please, with clause by clause?
Ms.
Thank you.
Dillon, and Mr. Genius, you'll have a point. If I don't answer, if my ruling is not what you think it should be, you can ask me to change that. Ms. Dillon, that's not a point of order technically. I do realize there are witnesses here that were here and came in to listen to clause by clause, and we should, as a committee, be respectful of that. But again, that's not, while your point was respectful, it's not a point of order. So. Mr. Genius, you want to say anything about that?
Chair, as you correctly said, it's not a point of order, but also Ms. Dillon has really insulted our guests today by claiming they don't know what's going on. She's also imputed opinions about the legislation to the officials, claiming
No, they
want
don't understand
something or
why
other
we're not
to
moving
happen.
forward. That's why they're here, okay?
Ms. Dillon,
You're just making things up as you go along.
I think the folks in the audience are very sophisticated people.
Yeah,
I
you were
think
sitting in
they
the back,
have
you don't
been
know.
in parliamentary
Yeah.
committees before.
That's
You were
enough.
sitting in the back. You
Mr. Chair, you chastened me for speaking during her point of order. I
You still
suspect
kept
you will now
talking, though.
chasten
So me
her
too, I'm going to do the same thing
Ms.
now.
Dillon, that's enough.
for doing the same.
Just finish your point, but
Yeah. Well, as
Please.
I was saying, just Ms. Dillon has been very disrespectful to our
No,
guests
I'm
by
not. You have been
suggesting that
disrespectful.
they
Your
are
whole
not
conservative
sophisticated enough
caucus
to
right here has
understand how
been very
parliamentary committees work. She's also suggested that they want certain things or don't want certain things. I don't think that's fair to them, and I don't think that's fair to the officials. The officials are here to do their job, which is to answer questions. They're not here to express
Not here to be
opinions.
abused.
So I think Ms. Dillon should apologize for the comments she made about the guests that are here at the committee.
thank you, Mr. Genius. We'll cede the floor back to Mr. Lawton.
Thank you. And again, it was quite interesting hearing Ms. Dillon really use people as political props for that point that she was making. There are a number of
Point of order,
stakeholders.
that's not what I'm doing. I'm trying to show respect to our audience members who are here. I just
That's not a point of order. That's a matter
acknowledge
of debate,
them being
Chair.
here.
Look, the reason I bring that up is because there are members of a variety of communities here who I have not actually seen testify before this committee. And if these witnesses are so invested in C9, and I hope that they are, I hope all of us are, why have the Liberals not allowed us to do a proper study on C9, bring these people here who have not testified, which includes some of them, I can't see everyone over there, bring them to testify as witnesses and have the consultation on Bill C9 that we were supposed to have? This is precisely the point that we're discussing. And now the Liberals have invited all of these stakeholders for a clause by clause that they themselves forced before this committee finished the work it needed to do on C9. A bill which, while I definitely understand the circumstances that have led to it, a bill which has, I don't actually believe I have gotten a single constituent email urging the speedy passage of C9. I have had emails from more constituents than I can count, and I'm just talking about as an MP. I'm not talking about emails I've received as a member of the Justice Committee from constituents saying you must stop this bill. And the reason is because they understand what the Liberal members choose not to, which is that this bill will attack freedom of expression. And when you want to force something through quickly that does not have cross-party consensus, it's only because you are concerned about what will be revealed when proper scrutiny and study is actually at stake. And I believe if you go back to the 3 meetings we were allowed to have on C9, what you would hear from our witnesses is that there was very little support for what C9 has actually done. And even witnesses who were conceptually supportive of C9 believed it needed changes that are so fundamental they would alter what the bill actually is. So if the Liberals believe that this bill needs to be passed immediately, they have to replace it with a bill that does not do what has been so alarming to people, again, from left and right, from religious groups representing a range of religions. You know, you have members of the Indian community that feel very personally targeted by this bill and feel that their religious freedom will not be protected. In the course of debate, as we have talked about changing the criminal code, by the way, changing the criminal code even beyond what C9 seeks to change, to remove the religious defense under Section 319, And in the course of discussion, when people see a member of parliament refer to verses of scripture as potentially hateful, all of a sudden religious people in Canada feel like they're going to be targeted by Bill C-9. So I don't understand how the government believes that a bill designed to attack hate against religion can do so by inciting hate against religion, and more importantly, against people who themselves are religious, which is the majority of Canadians. You know, we often heard Justin Trudeau talk about how diversity is our strength as a country. If you read through census data, not just in any of the constituencies that we represent, but across the country, you'll see a range of religious backgrounds and belief systems. You'll see denominations you never knew existed because we have such a diverse array of political and religious beliefs and cultural backgrounds and languages. And if we are to take a stand for religious freedom, we are taking a stand for all religious freedom. And people's religious beliefs influence their political beliefs. Their beliefs on, in some case, geopolitics. I mean, we've seen this at issue in what's been happening since October 7th. And we should be able to, in a free society, have these discussions and have these debates. We should be allowed to engage in the dialogue we need to reach the political conclusions that we need or the societal standards that we want to employ. Look, John Stuart Mill wrote one of the most seminal pieces on freedom of expression on liberty. Now, Mill was far more of a utilitarian than I am. But one of the things that he did so eloquently in On Liberty is talk about what freedom of expression gives us and the value of speaking with someone with whom you disagree. And what Mill wrote in this is that you speak to someone you disagree with, and what they do is they perhaps tell you that you're wrong. Maybe you go over to their perspective. Maybe you find a middle ground that you didn't know existed. Or maybe the act of debating and defending your position reinforces your beliefs. But no one loses when we have the freedom to engage in that dialogue. And it's interesting. You know, ironically, we're talking about freedom of expression here. We're talking about free speech, the right for people to speak their minds. And Ms. Latanzio is tweeting about me, how she doesn't want me to have a right to speak, how she doesn't want me to speak about these issues that have been raised by Canadians from far and wide about concerns they have on Bill C-9. And the Liberals may wish to, do what they're doing for social media clicks here, but the point of this is that we cannot take at face value. We cannot take at face value what they are telling us because they have shown an unwillingness to accept, even to go back to the Emergencies Act federal court decision, to even accept when a court has told them they broke the law, to accept when they have been found to have violated the most supreme law in this country, the Constitution of Canada. And Bill C-9, cloaked in noble intentions, is the gateway to UK-style social media policing. We've heard from the minister. It applies to what you see and say online. We saw the Liberals try to ram forward clause by clause while denying us 2 crucial meetings, 6 hours of witness testimony, and by their own admission, plenty of witnesses here engaged in the bill who have not had the opportunity to testify yet. I read through the list of some of them, dozens and dozens of witnesses, witnesses proposed by Liberals, witnesses proposed by Conservatives. There is an internal incoherence. One of these prospective witnesses, who we didn't get to hear from, Brian Duty, who I believe is a lawyer, said, he talks about the internal incoherence. He says that, we have in this law sections that belong in other sections of the criminal code. So he doesn't believe it was properly done. We had from the Hindu Canadian Foundation concerns regarding the use of the word swastika, a word that appropriates a very sacred symbol and ancient Sanskrit word for them, and concerns they have about things that resemble other things. We had also from the Canadian Women Against Anti-Semitism, a written submission on Bill C-9 by Talia Klein-Leighton. She submitted this brief. She talks about the ever-growing crisis of anti-Semitism and anti-Zionism. She says the amplification it's found in schools. We had a witness here when we were doing witness testimony on one of those 3 meetings who represented the Canadian Teachers Federation. And I didn't know at first, I hadn't read a brief from them, why the Canadian Teachers Federation wanted to testify about Bill C-9. And I was quite surprised when I learned it was because they were worried that teachers were subject to hate right now and that was going to be answered by C-9. And that witness had never heard of a report by the federal government talking about hate in schools, some of which comes from schools themselves, and in some cases from teachers. And the witness hadn't heard of that. So there is no objection from Conservatives that hate is a scourge in society. There are some very different beliefs on how to handle it. There are, from the Liberals, proposals that range from actively expanding what the state is permitted to censor, and there are proposals that, of course, come from the Conservatives, which is to enforce the law. Do not stand for people calling for violence on the streets. Do not stand for people who believe inciting genocide is their freedom of expression. Do not stand for people who are repeatedly terrorizing Jewish community members in this country. And I'm very aware, as someone who's been to Israel twice, as someone who has always been a supporter of the Jewish people, a supporter of the Jewish state, I'm very aware that there are members of the Jewish community that believe C-9 should pass, not because they think it's a good bill, but because they are desperate for something from this government. And that has been a message that I've heard, not just from stakeholders at the national level, but certainly from people that I've spoken to in my riding. People who are incredibly concerned, that realize the community is reeling. But again, they are not trusting this government. They do not trust this government. They simply believe that something needs to happen, and they're taking this little bit of breadcrumb that the Liberals are throwing them because the Liberals are trying to mask their failure to deal with this issue substantively. And I applaud my colleague, Mr. Baber, who I believe is next to speak on this motion before us right now, because he's tried to deal with this issue in a responsible, targeted way with Bill C-257, an act to amend the criminal code pertaining to promotion of terrorist activity or group. This bill is one the Liberals should get behind. Unlike Bill C-9, Bill C-257 does not change the definition of hate speech. It does not allow for this incredible mission creep by people that may have authoritarian impulses to rein in freedom of expression. It specifically narrows itself to those who willfully promote terrorist activity or terrorist groups or the activity of terrorist groups. And it's shocking in 2025 that such a bill is necessary. It's shocking that there has been such a blind eye turned in communities across the country to open, overt support for terrorists, for terrorist groups, for terrorism. I had a witness that I was speaking to on this committee. We all had a witness. I forget the name of the organization. He acknowledged a flaw in Bill C-9, and I didn't agree with his characterization, but I thought he had a right to express his opinion on this. And he was speaking about the issues with tying hate symbols that are banned to the list of terrorist entities. And on that list of terrorist entities, he said it's a very flawed process. And I asked him if Hamas belonged on the list, and he wouldn't give an answer. He wouldn't say whether Hamas was a terrorist group or not. So we do have some belief systems that we need to combat, but the way we combat this is by engaging in debate, engaging in discussion, engaging in dialogue. And it's interesting, the Liberal government is trying to shame us into passing bad, dangerous legislation. We are not going to back down on standing up for civil liberties. We are not going to back down on standing up for freedom of expression. We are not going to back down against standing up to a bill that does the very thing it claims to stop, especially if amendments that I suspect will be forthcoming, given dialogue that has happened on this committee, come forward that further erode religious freedom. And I go back to former Prime Minister Justin Trudeau, who interestingly said it was, quote, understandable that someone might want to burn a Christian church in Canada. That was echoed by his former principal secretary, Gerald Butts, who I believe his line was fully understandable, fully understandable. I do not believe anyone in this House of Commons would ever say the same thing had a synagogue been burned, had a mosque been burned, nor should they. To justify people that want to inflict significant damage, harmful damage, to religious institutions and by extension to terrorize people who adhere to those religions. And some of those ideas are embedded in the discussions we hear about how to combat hate. So I believe the Liberals need to shed the partisan games on C9. Do not force something through that we are clearly not ready for. Allow the proper study of it, but also align the priorities with the mandate of this committee. The reason we were denied witness testimony on Bill C9 was because, again, and I'm actually shocked by this. The reason that we were not able to hear from 6 hours of witnesses is because the Liberals decided to filibuster on a motion condemning the Supreme Court decision which condemned a mandatory minimum sentence of 1 year for people peddling in child sexual abuse and exploitation. Like, my goodness, if I had told anyone ahead of time that bill, that motion was going before this committee, they would have said, you know what, that should take like 90 seconds. You know, you can read the motion, everyone will throw their hand up and support it, and you can move on to C9. And I am a new member of Parliament. I'm still learning the ropes of how some of the rules and regulations on this place works. I realize you only have a finite number of time in the House of Commons and in committee to deal with certain things. And I realize it's frustrating when you have an agenda that's scheduled for one thing and you need to deal with another thing that came up. We didn't know when we started our study of C9 that the Supreme Court was going to decide to stand with pedophiles in the way that it did. And by extension, we didn't know that the Liberal government was going to similarly decide to stand with pedophiles. But that's what happened. And as a committee dealing with justice, we had to deal with that. But I hoped we could do it across party lines expeditiously. And it was the Liberal refusal to stand for a mandatory minimum sentence of 1 year on child sexual exploitation and abuse that led to blowing up the calendar for 2 meetings on C9, 3 meetings total, 9 hours that we could have been dealing with genuine justice issues. And instead, we were dealing with procedural wrangling, and ultimately it ended with, if anyone saw the last meeting, it ended with the Liberals supporting it because they thought they were voting on the amendment. So it's not even like they could filibuster all that effectively. But this is where we look at our priorities as a country, our priorities as a party, our priorities, frankly, as Canadians who care about justice, who care about law and order, who care about the Constitution and the freedoms it protects, and who understand that victims have rights as well. Children have rights. Victims of crime have rights. In my motion, the Liberal government, I hope, will adopt this motion when it goes before a vote, and I suspect there may be some others that wish to speak to it, but we are arguing for prioritizing Bill C-14. You know, I've spoken to police in my riding and across the country, and when they say the crucial public safety issues that they need action from this committee on to protect the streets and protect communities, they don't say, we are worried about what people say online. They say, hey, we're worried that we're arresting people, they're getting released on bail by a justice of the peace, and then we're rearresting them hours later. So C-14, which should have been the very first justice bill, in fact, I'd say it should have been Bill C-2. C-2, interestingly, on civil liberties, was the bill that the Liberals decided was supposed to be about border security, but in the end was about banning cash transactions, allowing warrantless search of letter mail, all of these other bizarre things that had nothing to do with border security. C-2 should have been the bail bill. That's what the priority should have been. But again, the government gets to set the agenda, and the government has decided to set an agenda that does not at all align with where Canadians are. And we cannot and will not pass bad law that censors what Canadians do simply because the Liberals are saying, just trust us. Because of this arbitrarily imposed calendar, clause-by-clause consideration, which was imposed without discussion, without debate, without an opportunity to debate, because the meeting was adjourned 2 hours early on Thursday. and with limited time to hear from witnesses. And by the way, I'm allowed to reveal this because it was going to be one of our motions. We had issued notice of a motion that we were going to table to extend the C9 study. Now, when you put a motion on notice, it doesn't become public, but all members of the committee see it. And I have to wonder if the reason we adjourned early was because the Liberals didn't want to have to say no to that motion, which would have been tabled, and vote against allowing more testimony on C9. Because I've been hearing from witnesses that have been very concerned that they didn't get the opportunity to have their say. You know, as early as this morning, I had a phone call from a stakeholder who was hoping to be able to testify and was wondering if there might be a last-ditch chance to get in, and could not. Because, again, of this artificially imposed deadline. And again, we could have had more information. We could have had more witness testimony. We could have had more insights had the Liberals not decided that 1 year was too cruel and unusual a punishment for people who traffic in child sexual exploitation and abuse material. And I find it shocking that that was what they decided was their hill to die on. Well, my hill to die on is freedom of expression. And this Liberal government has shown reckless disregard for that. When we engage in work as committee, we are the gatekeepers between law that has not been scrutinized, has not been vetted, has not been analyzed, and things that are passed by this House of Commons. When you try to aggressively and wrongfully accelerate the committee process, what you are doing is denying Canadians the opportunity to improve bad law or to, in some cases, gut terrible law. So when you try to speed up that process, it is either because you do not care what Canadians have to say, or more importantly, you know what they're going to say. And this is precisely what's happening on Bill C9. We have an artificially imposed deadline that we cannot meet and will not meet because we do not have the adequate information. And where we go from there, I don't know. I hope that we can agree to this programming motion that we have put forward, this programming motion that will allow for us to reset this committee's priorities, that we will be able to prioritize the study of Bill C-14, the bail and sentencing reform, which itself will need considerable amount of work, but I'm hoping we can, in the spirit of collaboration, proceed with that. The Block's study on judicial appointments, and in doing so, run them concurrently, reiterate to the Minister of Justice his outstanding invitation to appear to discuss his mandate and priorities, not just the one priority he wants to discuss, which is Bill C-9, but all of his priorities. I believe the Public Safety Minister we had also issued an invitation to, who has not yet taken us up on that offer. We know public safety and justice are very intertwined. There are a number of things that I think we need to hear from the Public Safety Minister on. One of them is whether he has managed to figure out in the last few months what a firearms license is. You know, crucial questions that I think should be asked of the minister responsible for confiscating firearms from law-abiding gun owners and, by extension, directing police resources to do anything other than uphold bail conditions. We are here at this committee because the Liberals could not make a very simple yes vote to denounce in no uncertain terms the Supreme Court decision which found that a mandatory minimum for someone who uses child sexual exploitation and abuse material is getting cruel and unusual punishment. That should have been almost an instantaneous decision, unanimous decision by this committee, and it was not.
Mr. Lawton ignores the fact that the reason that people couldn't vote for it was because he demanded to use the notwithstanding clause, the clause that takes away the rights of Canadians for no apparent reason when you could have legislative solutions that don't. He's mischaracterizing the entire thing. I know that's not a point of order, but I'm not going to let him get away with mischaracterizing what happened where the Conservatives filibustered C9 and continue to filibuster C9.
Indeed, debate. Mr. Lawton, floor.
There could have been consensus on this. The reason we put forward a motion that invoked the notwithstanding clause or called on the government to do it was because we need to protect against judicial activism, as was clearly the case in the initial trial court decisions in Quebec and then the ultimate decision that came from the Supreme Court. This is a crucial issue. We are not going to stand for a government that wants to hijack what Canadians care about, hijack the country's agenda to put forward its own attack on civil liberties. That is what this is about. That is why we are introducing this motion and why I have introduced this motion to reset the committee's work. I seek support from members on this motion, but I realize I've gone a couple of moments over where I was going to with my remarks, so I would at this time move to suspend this meeting.
Can we start the meeting?
Well, Mr. Chair.
We have to vote on suspending. Just all those in favor of suspending? All those against? We're suspended.
Suspending.
With apologies to witnesses and guests here today.
Ça va continuer,